This is Somnia Inc. and Resource Anesthesiology Associates of Michigan PC versus Capital Area Anesthesia PC et al. Docket number 21-35 CB. And this is the time set for hearing on the plaintiff's motion to enforce order and compel document production. And I will take your appearances first for the record, of course, starting with plaintiff.
Thank you. Good afternoon, Your Honor. This is Roger Myers. I'll be arguing on behalf of the plaintiffs, and with me I have co-counsel Stephen Paradise and Lena Gonzalez.
Good morning, Your Honor. Oh, I'm sorry. Good morning, Your Honor. Chirag Patel for the defendants, and I'll be taking argument for the defendants.
All right, thank you. Mr. Rogers, you may go ahead, your motion.
Thank you, Your Honor. You know, in most of my cases, it's pretty rare to be in front of a court on a motion, at least up until summary disposition. I try hard to avoid burdening the court with that. This is our third time in 6 weeks in front of this court. Two of them have been on other parties' motions, and then this one, of course, is our motion. In light of that, I know the court's familiar with the background, and I'm not going to belabor it unless the court has questions about that. But what's relevant for today is we're here about discovery that was served in January. And it's now mid-May. During that time, the defendants moved to stay the case, and the court heard argument on that on March 31st and denied their motion. As part of the order, the court gave them 1 week to respond to the complaint and also to respond to the discovery. Now, I'm not going to sit here and say that I anticipated that 1 week to respond to the discovery meant that they were going to produce every single document within a week. That'd be awfully burdensome. I'm not arguing that that's what the court did, and obviously the court knows what it did, but we're not arguing that. But what I do think the court's order meant is get going, get to work and start doing this. And they didn't do that. And what we found out is that in the 5 weeks since the court entered that order, they haven't collected documents. They haven't even engaged a vendor to assist them with that. And we're not guessing about that. At the time that we filed the motion, we had a strong suspicion that that's what happened. And we asked them twice in writing, tell us, have you started working on this or not? And they didn't answer that question. I finally did get an answer to it late last week. And the answer was, no, we haven't started collecting documents. We haven't engaged a vendor. And of course, in their response brief, they talk about it takes time to engage a vendor, it's expensive, et cetera. Well, Your Honor, I've been doing this for quite a while, and I do big business cases, and this is business court. So for me, dealing with millions of documents at a time is not unusual. It doesn't take 4 months or even 5 weeks to engage an e-discovery vendor. On most cases, I get it done within a day or two. If it's a huge case, it maybe takes me a couple of weeks to bid it out, but not 5 weeks, not 4 months. That's just not how it works. And the only excuse that we've gotten for why we're in this position today is tied to this ESI protocol that was under negotiation. And that's a red herring. You know, I think that an ESI protocol is a great idea. I frankly wish that more counsel were willing to discuss entering into an agreement in advance to try to organize the flow of discovery. And to their credit, the defendants proposed that very early on, almost immediately with when they were engaged. But again, that happened in late January, early February. And we said, you know what, that's a great idea. Happy to meet and confer about it. Let's get going. And I attached that email to our motion, but it was like February 3rd. And we had a few more back and forth, and they said, we'll get you a proposal the week of February 9th. Well, when I actually get the protocol, it's not until April 7th when their discovery response are due. So for 2 months, I don't know what they did, but they didn't send me something to negotiate back and forth. Be that as it may, we said, fine. We turned it around in a single day. So we get it on April 7th. We turn it back around on April 8th. Here's our thoughts on it. And then it's not again until April 22 days later, till April 30th, that I get version 3 of it. And it's got all sorts of changes and edits because in the meantime, they've now served discovery on us and they want to encapsulate all that into the protocol. And I understand they want to get that in there. And I was perfectly happy to negotiate that we will talk about our custodians, we'll talk about our keywords. That's fair. But what's not fair is making us continue to wait for our discovery that we served 4 months ago so that they can try to bring everything up to speed with discovery that they waited several months to serve. And they didn't want to tell us what was really going on. So we had to find that out. So this is not about the terms of the e-discovery protocol. In fact, I think we've got that wrapped up at this point, the actual terms of it. Maybe that'll have the success that we won't end up fighting about, the scope of production or things like that. But today is about timing, and it's about delay, and it's about using the ESI protocol as a tool to string this case out instead of proceeding in an orderly fashion. There's a couple other things this is not about. It's not about the defendants having produced numerous documents. And that's a quote that I take from page 2 of their response brief. Your Honor, they've produced 22 documents in this case. 19 of them they gave to us on April 7th, and then they gave us 3 more on April 9th. And I suppose just to give them credit, they gave us 2 insurance policies a few days ago, so maybe it's 24 documents. That is not numerous documents. This is an ESI case about the text messages and emails they sent to a whole bunch of people, and that's the stuff that they have not set out in an orderly fashion to collect and start working their way through. And I don't disagree with Mr. Patel in his response when he says, it takes time to do that. It's a lot of work, and we want to do it in an orderly fashion. I get all that, and I agree. But that's what they've had months and months and months to do, and certainly the last 5 weeks since Your Honor ruled, and they have elected not to take that obligation seriously and move the process forward. Here's the other thing that this is not about. It's not about mediation, and it's not about settlement. We did have a mediation on Monday, and frankly, I'm surprised to see that as the centerpiece of their brief. I'm not going to get into the details of that because I don't think it's appropriate. And the only thing I'll say is we came in good faith, the hospital came in good faith, and we resolved that dispute. We did not resolve the dispute with the defendants here. And what they still seem to be doing is not taking seriously the fact that this is roughly a $14 million case that we have brought because we had serious damages that resulted from their actions. And they're really the ones that are holding the documents that demonstrate the proofs on this claim. And they absolutely need to start putting those documents out. And the only way that we can get that pipeline open is to have the court hold their feet to the fire at this point because they seem to not be willing to do it for themselves. Your Honor, if you have any questions, I'm happy to answer them. But at this point, this seems like about as straightforward an issue as it comes. And so again, I'm not going to belabor it, and I'll be happy to just stop by asking the court to grant the motion.
All right, thank you. Mr. Patel?
Good morning or good afternoon, Your Honor. One thing I want to quickly address, I did not attend the mediation, but Stephanie Jones, as the other counsel on this case, did attend the mediation. And we did come into that mediation hoping that we would have a resolution of that. But my understanding is that the mediation started at 9:30 a.m., but they did not issue a demand to us until 3 p.m. for a mediation that was going to be ending at 4:30. So I don't know, I wasn't there, but I suspect that there wasn't actually reasonable efforts made to resolve the case with us. We came in hoping that would happen. And I don't think that the lack of a resolution between Somnia and plaintiffs was based on any lack of desire on our parts. Now, moving into the issue at hand, Your Honor, I think everyone would acknowledge that discovery is meant to be managed by the parties with minimal court intervention, and court intervention is appropriate when there's been significant dilatory conduct by the parties and reasonable attempts to confer have failed. I don't think that they've made that case here, and I'm going to kind of go through what we've done since the April 5th order. Prior to that April 5, Your Honor, we had filed a motion to stay. We had a legal and a public policy reason for doing so. We thought that waiting until the resolution of the arbitration between Somnia and MGL would bring significant deficiencies. But as Roger said, after the court entered the April 5th order, it was meant to say, get to work. And that's what we did. After April 5, as ordered by the court, we filed an answer on behalf of 12 defendants. We answered interrogatories on behalf of 12 defendants. We responded to 12 sets of requests for production. We made initial productions based on the doctor defendants taking efforts to self-identify relevant documents. The plaintiffs issued a discovery deficiency letter to us based on our response to discovery. We met and conferred with them on that letter, and then made a supplemental production within 10 days of that meet and confer. We participated in a mediation on Monday, which also required the preparation of mediation statements. So that took time and effort as well. Contrary to what Mr. Myers said, we did take efforts to engage an ESI vendor. And one thing that we specifically, I want to make very clear, is we did not say that we would not begin production until after the ESI protocol was finalized. We never said that. And in fact, I said the very contrary during our meet and confer with Mr. Myers regarding his discovery deficiency letter, because he asked about that. He said, you know, regarding search terms, we may have our own objections, and you've just recently served discovery. And I said, I understand that. We understand that the discovery is going to be on 2 separate tracks based on the fact that you served discovery with your complaint, and we just recently served discovery. So then we went through the process of engaging vendors. We have 2 insurance companies involved. Mr. Myers has the policies for those, so we needed to get approvals from them and the clients. And this stuff does take time, but we have got one retained, and we've got a call scheduled with them tomorrow. And to begin, the other issue is, as well as, you know, Your Honor, these ESI vendors aren't ready to just pick up from the point of being retained. They have lead time. They don't have people just sitting around waiting to begin the productions. They have to find staffing, and then once they have staffing available, that's when all of this happens. And all of this is now in action. And as Mr. Myers acknowledged, the parties are now in essential agreement as to at least defendants' obligations in the ESI protocol, and we've said that we'd abide by it. Regarding plaintiffs' obligations, we've still got a few things sorted out, but we never said that we would withhold on our efforts to produce documents based on the outstanding issues that we have with plaintiffs. So that's a significant progress that we've made in the last 40 days or so since the court's order. During that meet and confer in late April regarding plaintiff's deficiency letter, we informed plaintiffs that one of the reasons that there was kind of a delay in the getting comments on the ESI protocol is that we were addressing the supplemental requests for information based on the discovery deficiency letter and the ESI protocol with the defense at the same time. And with 12 defendants, working with 12 defendants, we wanted to address all those issues contemporaneously because it was far more efficient for us to do so. And the 2 issues were interrelated because items in the ESI protocol had to do with stuff that would be relevant to discovery, like asking them on their input about keywords, relevant sources of ESI, who would be the relevant custodian. So we wanted to get all that together at the same time and bring that back to plaintiffs all at once. Another thing that I want to point out is that plaintiffs have had a bit of a head start, at least I believe, on learning the facts of this case through their arbitration with McLaren. And so we're still learning the case, and we needed input from the clients to determine what are the relevant issues. Like I said, who are the key players? What are the potential sources of ESI? Once we got that client input, we turned back the ESI protocol. At that same conference with plaintiffs' counsel, I told them that we were engaging a vendor and we would need to get things lined up. And because I think what Mr. Myers wanted us to do is continue our self-collection. And I said that we'd be getting a vendor to help with collection of emails, cloud devices, and mobile devices for the 13 different custodians that they've identified. And that manual collection to get the same information that would be systematically collected by the vendor would be duplicative of that information. So it would be an inefficient effort. So it's true getting the vendor lined up. I disagree with him on some of the statements he made about when we engage the vendor and how long it should take to get a vendor and get approvals and all those things. I think we've moved in a very reasonable pace, but it does take more time than doing a bunch of manual upfront collections. But in the end, it'll be less effort for 12 defendant doctors. It'll be more cost efficient, and it'll be frankly more complete because the collection is being done in a systematic way by a third party. Based on the posture of the case, the benefits are worth the additional time. There are no deadlines. There's no imminent harm. There's no injunctive action requiring expedited discovery. There's no fire. This court is having its initial case management conference next week. There's also an assertion in the motion that we were, again, trying to lock in search terms and adding information in the ESI protocol is an effort to delay. That's entirely untrue. And I think I've addressed that earlier by clarifying that, and stating specifically to plaintiffs' counsel that we were not going to make our production schedule based on us finalizing the plaintiff's obligations under the ESI protocol. We were just providing additional information to move that process forward. And then again, relating to efforts to confer, Your Honor, I want to note that the plaintiff's last email that they attached to their motion is 4:54 p.m. on a Friday. Mediation briefs were due on Monday, 5/3, and they filed their motion on 5/4 at 10 a.m. So they didn't give us a whole lot of time to respond before vaguely threatening to seek relief if we didn't give them information about our progress on e-discovery. Meanwhile, we give defendants an extension of time to respond to our discovery request because they wanted additional time because of their pending arbitration with McLaren. And at first they accused us of not giving them additional time, but they never requested it. But as soon as they did, we said they could take as much time as they needed. And one thing that is kind of curious to me is that if plaintiffs don't have time to respond to discovery requests at the time that they're praying for arbitration, it's unlikely that they're going to be reviewing our production. So it seems to me that part of the push was only to push. There wasn't going to be any reason for them to get documents before the arbitration or soon, because they weren't going to have time to look for them. It was simply to make us work. Discovery is not meant to be a tool of oppression. This is supported by MCR 2.302, which allows the court to enter protective orders to protect against discovery requests that are oppressive and pose an undue burden and expense. And I have a supporting citation as that as well, but it wasn't cited in my brief. So again, as Mr. Myers has indicated, we've now reached an agreement on our ESA protocol. We have a vendor, everything's in place. So I'm not really sure what's left to do here. Everything's moving forward, and it's moved forward at a reasonable pace. The relief that's requested by the defendants is entirely unreasonable. We don't know the volume of ESI yet, but completing collection, review, and production of potentially significant volume of ESI within 2 weeks would impose an impossible, if at minimum, a very significant cost and burden on defendants. And there's nothing to justify that burden. There are no deadlines. There's no case. There is a case management conference next week, and plaintiffs won't begin their own productions probably until mid-June. And if they need more time, of course, we would have no issue with that. So the facts presented in this case don't warrant the court's management of defendant's discovery or entry of any deadlines for production. We've acted with reasonable diligence, and the court, again, is likely to set a case management conference or with relevant deadlines next week. If the court is contemplating entering an order, it should not be a firm production date, because we just don't know what's going to be in the production. And what we have suggested to plaintiffs in negotiating the ESI protocol is that the parties confer once we collect ESI. We run the search terms and we determine what the volume is. If necessary, we would then confer on modifying those search terms to reduce the volume. But if the volume seems appropriate, then we could discuss a reasonable schedule for production based on the responsive volume. So if anything, if the court's contemplating entry in order, I think it should be a date to confer, not a date for production. But again, we don't believe that intervention is appropriate, and we ask the court to summarily deny the plaintiff's motion.
All right, thank you. Mr. Myers, do you want the last word here?
I do, Your Honor. Thank you. 3 brief points in response to Mr. Patel's statements. There was an awful lot that Mr. Patel said that was outside of the briefing on the record. I'm really not going to address much of that, other than to just say that we're not being difficult working with them. They sent us 79 interrogatories, and in connection with 79 interrogatories, which we said was plainly improper under the court rule, they also twice told us in writing they expected responses within 28 days. That's what we reacted to and said, really, I mean, we've given you multiple extensions and you doubled the discovery. And by the way, Your Honor, we ultimately agreed that we'd respond to those as an accommodation. So I think the suggestion that we have not been playing well in discovery is just not appropriate. The second thing Mr. Patel said is that there was some suggestion that we might be expecting both a manual and a vendor guided collection. We've never said that. We've never suggested that. And we don't expect that. What we expected was simply for them to begin actually doing the vendor collection that's clearly appropriate here. The last thing I want to do is and I think that Mr. Patel, I kind of showcased this, so I won't belabor it, but on May 7th, his email, when he told us that they didn't have a collection completed yet, May 7th, he says, we are onboarding a vendor for the remaining ESI. And then he goes on to say the vendor will be collecting ESI. So we interpret that as the vendor is not up to speed and hasn't collected yet. And then he says, as soon as we complete collection and run search terms, hasn't happened yet, we will seek to confer with you regarding responsive volume and production timelines. Thereafter, we will begin review and rolling production, but we won't know the overall timing of completing production until we know the type of volume we are dealing with. And that, Your Honor, just circles me back to where we are today, which is I have absolutely no timeline that I can depend on. I have no idea when these documents are going to come in. It just seems to be one delay after another whenever they get around to it, and that's just not appropriate. They've had 4 months. It's time for them to actually act and do, and that's what we'd like the court to order them to do.
All right, thank you. Well, this case, it's funny in a way that we are having this discovery discussion that goes back to February, perhaps, when we haven't even had a scheduling conference on the case yet, which is scheduled for Monday. That said, The plaintiff has certainly been diligent in pushing their desire to have discovery go forward way back in February and since then, and have put the defendants on notice multiple times that they expected that this ESI protocol would go forward and that their searching would begin under the ESI protocol. That said, I don't think that there was an accepted ESI protocol until it looks like maybe April 30th, when plaintiff's counsel sent the email saying everything's accepted short of search terms for us, so search terms for the plaintiff. It seems to me, in looking at the communications, that the defendants were holding up their own ESI production because there weren't agreed upon search terms as to the plaintiff's production. But again, that's just not justified, and it's not justified because, again, the plaintiffs have been insisting on this production for quite some time now, and I ordered it. Now, true, I did not intend to order all the discovery in the case to be done in a week. If I recall, plaintiffs had asked in that motion that the discovery be produced immediately. So, a week was more lenient than what the plaintiffs were asking for. But again, at the time that I ruled on that, I have no idea, because we haven't had a scheduling conference yet, what the depth and breadth of this ESI is. That's when I get a chance to talk to counsel about issues such as this. So, even though I ordered it, I didn't really have a clear, firm 7 days in mind because I didn't know what it entailed. But yes, I think we could call it a get to work order. And it's a little dismaying that the defendants haven't gotten to work very much. They seem to have dragged their feet. But I think at this point, there's an accepted ESI protocol, at least with respect to the defendant's production. I can't say it was really agreed upon until April 30th, but the defendants have been on notice to get to work. I will compel the production of the ESI. However, I am not going to put a time limit on it right now. I think the plaintiffs can wait until Monday, when we have our scheduling conference, when we can have a more in-depth discussion about what the case entails and what the reasonable timeframes are in which to get this done. But I advise defendants in the meantime to get to work and come to the scheduling conference, virtually that is, with some really clear information on when this can be accomplished. And if it's not in the immediate future, what the impediments are, and have some real information that's worthy of discussion with the attorneys in the court. So I'll grant the order to compel, but again, leave open right now until Monday what kind of a time frame we're talking about, so we can see how it fits in with other discovery as well.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, and so I'll see you all on Monday. I forget the time, it's in the morning, but we'll be all meeting on Zoom.
Thank
Very
you.
good. See you then. Have a
Nice
good
day.
weekend.